An agent is a person employed to do any act for another or to represent in dealing with third persons. An agent is bound to render proper accounts to his principal on demand. At any given point of time, an agent will not be given any rights to deal with the account of the principal. Good morning and welcome to the session 6 in Unit 3 Commercial Law, where we are going to speak about the duties of an agent. Now let's go further and try to get introduced ourselves to who is this person called agent. An agent is a person employed to do any act for another or to represent in dealing with third persons. So we know there are different types of agents like LIC agents, house broking agents, or when we talk about insurance agents, or when we talk about automobile brokerage agents. There are several kinds of agents. So what is an agent all about? The agent is a person who's employed to do any act for another, not for himself, for another, or to represent another. So on behalf of me, an agent will represent in one dealing. So I ask an agent to get me a second-hand car. So on behalf of me, this person is going to come forward and he is going to deal with the third persons. The person for whom such act is done or for who it is represented is called as the principal. Now in this case, I am the principal. I will appoint an agent who will go on behalf of me and deal with a third party to get me a car. So this is how we are going to define an agent. The contract between principal and agent is called as the contract of agency. So the contract that I have with me and the agent is called as the contract of agency. The rights and duties of the agent corresponding to the duties. Now what is going to happen is that let us try to understand the rights and duties, but before that, so we need to understand principal and the agent. The contract between them is called as the contract of agency. Moving further, what are the duties of an agent? The agent's duty in conducting principal's business, that is my business, as per the section 211. Let's try to understand what are the duties here. An agent is bound to conduct the business of his principal according to the directions given by the principal, or in the absence of any such directions, according to the custom that prevails in doing that same kind of business. Now what happens here is that agent is not a person who can act on his own. Agent cannot make any decisions. The agent's decisions are bound by the principal. So the principal will direct the agent and tell what needs to be done, how it needs to be done, what are all the different factors. All those things will be told by the principal to the agent. Suppose in the case, if the principal is not there, then as per the thumb rule, you need to follow the customs of doing that business. You cannot innovate your own ideas and do business here. So whatever has been instructed to the agent has to follow it. When the agent otherwise, if any loss sustained, he will make it to the good to his principal, and if any profit accrues, he must account for it. So what will happen here is that when the agent acts otherwise, if any loss will be sustained, he will be making liable to pay it to his principal, and if any profit comes into picture, he must account for it. So he must go and tell to his principal, this is the profit that we have made. Followed by the illustration here. Let us look into an example. A is an agent engaged in carrying on for B. So A is the agent, B is the principal here, in which it's a custom to invest from time to time the interest, the money which might be in the hand on its such investment. A must make good to B the interest usually obtained by such investment. Now let's try to understand this mutual fund agencies or portfolio managers altogether. The portfolio manager here is an agent and you are the principal. So you will tell the person that is your agent clearly how to invest the money in various sectors. Why? Because he will give you ideas, suggestions, but it is finally your decision, your call to make the factor clear that how you want the money to be invested. So what he does is that time on time, whenever the interest accrues, whenever the profit is made, it is the duty of the agent to report back to the principal and put it back into his account. So that's where the role of agent comes into picture. Be a broker on whose business is not accustomed to sell on credit, sells goods of A on credit to C. Now B is the broker, he is going to sell the goods of A. A is the principal to a third party called as C, whose credit at the time was very high. So what happens? C before payment becomes insolvent. Therefore, B must repay back the loss to A. Now, this is where the second factor comes into it. Suppose in case of a principal agent, while you are transacting the business, representing the principal, and there is a loss that is accrued, then the agent is responsible to compensate the loss back to the principal. That is a very, very important factor here. If the profit accrues, he has to go and put it back to his account. He has to account for it to the principal. If there is a loss made by the agent, then he has to compensate back for that loss. Followed by skill and diligence required from agent. It is given under this section 212. An agent is bound to conduct the business of an agency with as much skill generally possessed by the persons engaged in similar business unless the principal has notice of his want of skill. Now, what happens normally whenever you talk to an agent, you believe that that person has got reasonable knowledge about the business that he is involved into. Now, for example, if a person comes to you and asks about second-hand cars, then you should have a reasonable knowledge about the automobile. Which kind of car, what brand, what is the cost, how many kilometers run, what kind of dealings that are involved. That is a general skill that is expected from you. But if you don't have the general skill, then it becomes very difficult for you to run that particular business. Now, the agent is always bound to act with reasonable diligence, which means the factor of common sense has to prevail upon the agent at any given point of time and to make the compensation to his principal in respect to the direct consequence of his own neglect, skill or misconduct. That is why it is always important that you first understand the business. You need to get into it where you are getting into that particular line or particular zone altogether, which means to say that at any given point of time, one thing that is important for us, one thing that is very, very important for us to see here is that we should not take anything for advantage or granted and just get into a business. Why? Because tomorrow if you make a loss on behalf of the principal, then you are responsible to pay back the money to that person. So it is mandatory that you know the business, you don't do any misconduct, you don't do any kind of misappropriation, or you do not do any illegal transactions so that you land up the client on a loss mode. If that is going to happen, it will be the duty of the agent to go back and compensate it to the principal for the misconduct that has happened. Followed by an illustration. Let's look at an example here. A is a merchant in Calcutta. He has an agent in London. So A is the principal, B is the agent there, to whom a sum of money is paid on A's account with the orders to remit. So he has told B, remit this money. B retains the money for a considerable time. Definitely, yes, he is holding it for a considerable time. A, in consequence of receiving the money, becomes completely insolvent. Because what is happening here? He tries to, B will try to hold the money. Because of that holding, A, in consequence of not receiving, he becomes insolvent. B is liable for the money and the interest from the day which it is ought to be paid according to the usual rate, and any further direct loss because of the variation, but not more than the actual factors. So what is happening here is that somebody has given the money to you to put it into the account. But if you just keep the money and not retain it, because of which the principal has got now affected, he has become insolvent, he has completely become cash trapped altogether. The reason is the agent. So the agent's responsibility is now to repay back the money with the interest, including the variation in exchange of currency. Now, moving further, A as an agent for the sale of goods having authority to sell on credit, sells to B on credit. So A as an agent who go ahead and sells the good to B on credit without making proper inquiries about the solvency of B. He just went ahead, sold the goods to B on credit because he just wanted to make a sale. He didn't make a proper diligent report. He did not inquire at all, just went ahead. B at the time of such sale is insolvent. By the time the sale was made, he is insolvent. A must make the compensation to his principal. Why? Because he should have taken the proper care. He should have understood the situation. He should have first made a diligent report about that situation. He should have come back, understood that scenario, and then he should have made the sale. But now, because of his mistake, who is going to take the repercussion? The principal has to bear the expenses. So now it is for A, the agent, to go back and pay the compensation to the principal. A is also an insurance broker employed by B to effect an insurance on ship. Omits to see that the usual clauses are inserted in the policy. The ship afterwards is lost. The consequence of omission of clauses, nothing can be recovered from the underwriters. A is bound to make a good to the loss B. Now what happens? A is an insurance agent who has been appointed by B in order to make an insurance for the ship. As per the bad luck, the ship gets completely lost, and when it happens, A did not take care of making the proper clauses which needs to be written, which needs to be shown to the underwriter. So now when B goes to the insurance company and claims for the loss, the shipping agent, the underwriters say that there was no clause made, there was no proper documentation made. Now it becomes the responsibility of the agent to repay back to the principal. This is the case all about. Moving forward, the another example is that A merchant in England, direct B is his agent at Mumbai, who accepts the agency to send him 100 bales of cotton by a certain ship. B, having its power to send the cotton, omits to do so. The ship arrives safely in England. Soon after the arrival, the price of cotton rises. B is bound to make a good to A the profit which he might have made by the 100 bales of cotton at the time ship arrived, but not the profit he might have made by the subsequent rise. Now please understand the scenario. A is a person in London who has appointed B as an agent, and he has told him to send 100 bales of cotton through a ship. But the agent, as usual, forgets about it, and the ship goes out sailing to London without the bales of cotton. As the bales of cotton tend to increase, there might be a profit which would have been made by A. Since the agent did not follow the instructions and he just allowed the ship to sail, now what is going to happen? The loss that has happened has to be compensated by the agent to the principal. So that's why we are now talking about the factor that he has to repay back the compensation. Why? Because if that 100 bales of cotton would have arrived on time, then the principal would have definitely made some profit. Followed by the duty to render proper accounts. It's very, very important. According to section 213 of the Indian Contract Act 1872, an agent is bound to render proper accounts to his principal on demand. This is very, very clear and important. According to section 213 of the Indian Contract Act 1872, agent is bound to render proper accounts, which means he has to give a complete detailed status of his accounts, what he has used, how he has used. All those details have to be given on time. So that's why we say it is a duty of agent to maintain the proper accounts, and this is given under section 213. Followed by duty to communicate with the principal. It is the duty of the agent in case of difficulty to use all the reasonable diligence in terms of communicating it back to the principal and telling him on the time what are all the changes, what are all the things that have happened on an emergency, exigency basis, if there is any change of plan, if there is any change of due course of action, whatever might be the slightest change in the transaction, in the procedure, it has to be reported back to the principal on time so that the agent is able to carry forward his duty, and the principal also knows what is happening in this situation. Followed by not to deal on his own account. Section 215 of the Indian Contract Act 1872 deals with the right of the principal when the agent deals on his own account, a business agency, without principal's consent. Now what happens here is that it says, section 215 says that if an agent deals on his own account in the business of agency without keeping the principal posted or informed, without his consent, and acquainting him with all material circumstances which might have come to his knowledge of the subject, the principal may either repudiate, that is send him back, transact the entire thing out, cancel the transaction, if the case shows any material fact of dishonesty concealed by him, or the dealings that have been made disadvantageous. So that will lead to the immediate truncation of the agency, stating that because he has acted without his permission, he has shown dishonesty in terms of dealing that particular account. At any given point of time, an agent will not be given any rights to deal with the account of the principal. But if the agent takes the ownership on himself and tries to do something which is not prescribed without the consent of the principal, and that leads to loss, or that leads to some kind of material fact which would put the principal under a disadvantageous position, then we would call that situation where the principal can go ahead and truncate the entire contract. Followed by the examples here. A directs B to sell A's estate. So A is the principal, B is the agent. Now A is telling to B, sell my estate. B buys the estate for himself in the name of somebody else, that is C. A, on discovering that B has bought the estate by himself, may repudiate that sale if he can show by proof that B has used dishonesty by concealing the name, concealing the details and doing it. So any kind of concealment, any kind of dishonesty, any kind of misrepresentation or fraudulent activities involved in the transaction can lead to the truncation of the contract immediately. Now the second factor, A directs B to sell A's estate. B, looking over the estate before sells it, finds a mine on the estate which is unknown to A. B informs A that he wishes to buy the estate for himself, but conceals the discovery of mine because he does not want to reveal the profit that can be got there. A allows to buy in ignorance of existence of the mine. Now you see that the information is concealed. He is trying to hide the information. A, on discovering that B knew the mine at the time he bought the estate, may either cancel or adopt the sale at his option. So now what will happen? Once if A comes to know the truth that B has hidden the fact of mine being there, automatically this becomes an option for the principal, that is A, to cancel the transaction, cancel the sale at all. So that is why this is very, very important for an agent to be transparent and truthful in all the transactions that are done by him. Followed by not to make secret profits. This is very, very important again. Section 216 of the Indian Contract Act deals with the principal's rights to benefit gained by the agent dealing on his own account of agency. An agent without the knowledge of the principal should not deal in the business of agency in his own, trying to make his own profit. An agent without the knowledge of the principal should not deal and make secret profits. Now, in the name of the owner itself, if I start making deals and I start taking profits, then that is said to be completely illegal. So, Section 216 of the Indian Contract Act says very, very clearly, if an agent without the knowledge of the principal deals in the business agency and tries to make money, then that would become a serious issue where the principal will have the right to claim any benefit, and that might also go in for a legal case altogether. Now, the next one is an example where you can see that A directs B, his agent, to buy a certain house for him. B tells A it cannot be bought and buys the house for himself. So he takes the advantage position. A might discover that B has bought the house, compel him to sell it to A at the price he gave it for. So that is now, A will now go back and say that you have to give it back the house at the price what he bought it, because he has concealed, he has cheated, he has done the business on himself without letting the principal know about it. That's like a secret profit case altogether. Followed by duty to pay sums received from the principal. As per Section 218 of the Act, agent is bound to pay the principal all sums received in his account. So on the behalf of the company only he is working, on the behalf of the principal only he is working. So any amount that is received in his account based on the transactions made has to go back to the principal. So principal should always be noted about what is happening. It is the duty of the agent to go back and reveal the profits back, give back the sums to him and let him know what are the transactions done. Where it is found under Section 218, where it clearly says that the agent has to pay back the sums received to the principal itself. Followed by not to disclose the secret. Suppose it is being told that there is a non-disclosure act. So it is the duty of the agent to maintain secrecy. Now there is something called as NDA, which stands for Non-Disclosure Act. You are not supposed to reveal the acts, reveal the secrets of the business. So that is why we call it as a confidential matter. It's kind of a secret altogether. So moment you say it is confidential in nature, it is the duty of the agent to follow that rule and not reveal the secrets outside. With this, I come to the end of this particular session. I hope and believe that all the information shared through this session will be of a great help and resource to you. In the upcoming sessions, we shall learn more about the commercial law terms and regulations. Until then, stay tuned, stay blessed, and stay enlightened forever. Thank you once again for joining me today on this wonderful session.